In attempting to bend the United States Supreme Court to its will, Congress suffered an embarrassing rebuke by the court in the case of City of Boerne versus Flores. But to make sense of what happened in Boerne, we first must understand a prior case called Employment Div versus Smith. In Smith, the state of Oregon denied unemployment benefits to members of a Native American church who lost their jobs after smoking peyote. The church members argued that Oregon's prohibition of peyote violated the Free Exercise Clause of the First Amendment because they had consumed peyote as part of a religious ritual. The United States Supreme Court held that the law prohibiting peyote was constitutional because it was a generally applicable criminal law that governed everyone and didn't target a specific group, race, or religion. Many members of Congress were deeply unhappy with the court's decision in Smith. In response, by a bipartisan majority, Congress passed the Religious Freedom Restoration Act, which prohibited the federal and state governments from substantially burdening a person's free exercise of religion, even if the burden results from a generally applicable law. By targeting laws that are generally applicable, Congress sought to undo the Smith precedent. After the act was passed, a church in Boerne, Texas wanted to build a larger church. The church applied for a building permit, but the city's zoning board denied the request, citing a zoning ordinance that prohibited alteration of historical landmarks. Upset by the denial, the church challenged the zoning ordinance under the Religious Freedom Restoration Act. The district court held the Religious Freedom Restoration Act to be unconstitutional, so the church couldn't rely on it. The Court of Appeals reversed, and the United States Supreme Court granted cert. The issue before the Supreme Court was whether the Religious Freedom Restoration Act was a proper exercise of Congress's authority to enforce by appropriate legislation the constitutional guarantee of equal protection of the laws under Section 5 of the 14th Amendment. The court held that the act was outside the scope of Congress's remedial enforcement powers under Section 5 of the 14th Amendment because the act sought to change the meaning of a constitutional right that the court had defined in Smith. Justice Kennedy, writing for the six-justice majority, explained that Congress has the power to prevent or remedy the violation of a constitutional right. But Congress doesn't have the power to define the meaning of a constitutional right. That power belongs exclusively to the court. In Smith, the court had interpreted the Free Exercise Clause to provide no religious exemption from generally applicable laws. Congress's attempt to disregard the court's precedent and create broad religious exemptions from generally applicable laws infringed on the court's role to interpret constitutional rights. Additionally, the court held that the act was overly broad in scope. Kennedy explained that for remedial measures to pass constitutional muster, there must be, quote, congruence between the means used and the ends to be achieved, unquote. Here, instead of targeting only those laws motivated by religious bigotry, the act gave Congress a blank check to displace a wide variety of state laws, even if those laws didn't single out religion for unfavorable treatment. The court reversed the Court of Appeals and struck down the Religious Freedom Restoration Act as unconstitutional. Justice Stevens wrote a concurring opinion to argue that the act violated the Establishment Clause. Stevens understood the act to promote religion because an atheist wouldn't have a cause of action under the act. Justice Souter, in a dissenting opinion, argued that this case should be re-argued for a wholesale re-examination of the rule in Smith. According to Souter, Smith created tension within free exercise jurisprudence and should be re-evaluated before being applied to the merits of Flores's case. Also dissenting, Justice O'Connor argued that the court misinterpreted the Free Exercise Clause in Smith, which improperly restricted the free exercise of religion. O'Connor examined historical materials, suggesting that the framers viewed the Free Exercise Clause as a guarantee against the imposition of state burdens on religious practice, even when that burden results from generally applicable laws. Justice Scalia wrote a concurring opinion to respond to Justice O'Connor's dissent. He criticized O'Connor's argument that historical evidence shows Smith to be incorrect, calling it a, quote, extravagant claim, unquote. City of Boerne versus Flores is well known for its strong rebuke of Congress. After this case, Congress would do well to think twice before attempting to override the court's explicit interpretation of a constitutional right.